Northern States Power Company. This is in docket 17-410. This is involves the Freeborn County wind facility. Mr. Kaluzniak is available for questions, and there are parties that filed comments available here for questions.
Okay, we had extensive briefing papers on this subject. Mr. Kaluzniak, thank you. Anything to add at this point?
Thank you, Madam Chair. I would just note one typographic error on page 1 of Exhibit B, or Attachment B. At Section 4, it references the need for 1,000 petitioners' signatures, and it should actually read 100 per the operative statute under the EQB rules. I see that representatives from AFCL and Excel are available, as well as the department, if you have any questions.
Thank you.
May I make a comment?
Yes, Ms. Overland, just please sit down and introduce yourself for the record.
Carol Overland, representing Association of Freeborn County Landowners. I want to point out that there is a substantial error in the briefing papers, and that there were 388, I believe, 380 plus signatures included, and that hasn't been corrected that I can see. And so I want to make sure that the commissioners are aware that there were those signatures present.
Okay, just so make sure I'm following what you're saying.
Sure.
On, I see a summary of our statute and rules, and you want the record to reflect that in your estimation there were more than 300 signatures on page 5, where it talks about, I see in the first full paragraph on page 5, it says AFCL stated that its petition included 380 signatories. Is that what you wanted corrected?
No, I'm referring to page 6 of the briefing papers, where it talks about EAW petition deficiency, it says that it is deficient, and number 1, it is not deficient.
Wait, I'm sorry, I'm not following where you're
Briefing
at.
papers, page 6, under 5, Roman numeral 5, staff analysis, EAW petition deficiency. And first, it was not deficient. There were 380 plus signatures. And then second, it is not for the commission to decide whether or not a petition is sufficient or not. That is the job of the EQB. And I recognize, the commission doesn't deal with EAW petitions very often. But, that's a fundamental point. And so, again, that's mentioned on, there are other places too in the decision options. So there we are. Page 7, again, on applicability, that paragraph, it also says, notwithstanding the petition's deficiencies, and the petition was not deficient. That was determined by the Environmental Quality Board. And the Environmental Quality Board did send a letter to the commission, which I don't believe is listed in the no, I don't believe it's listed in the attachments for the commission, but the EQB did send a letter to staff explaining that those were there and that it was not deficient, and that the EQB did verify the petition. And I don't see that here, but that was sent.
Yep. And Mr. Kaluzniak, that is in e-dockets, I assume?
Madam Chair, what I posted to e-dockets was all the information provided to staff from the Environmental Quality Board. It's somewhat unusual in 2 respects. One, as Ms. Overland states, the petitions from EQB are under their operative rules and not ours. We usually require service under Minnesota Statutes 216, as you know, electronically from other state agencies. We did not receive that directly. We were provided an FTP, a file transfer protocol subdirectory within the EQB and PCA servers. I downloaded that information. I have copies available. Within those documents, there was not a copy of the petition. Staff does not dispute the fact that there are 358 signatories to it. And in fact, the decisions before you are not predicated upon that. So it shouldn't be an issue. I pointed out just merely as a matter of course that the items that we were presented were deficient in that they did not include those signatures.
Okay, thank you, Mr. Kaluzniak.
Madam Chair?
Yes, Ms. Overland.
When the petition was referred, transmitted is the word that EQB used, when that was transmitted, there was that FTP link. The petition was there, and there was also a claim in here that two attachments were missing. I believe it was Appendix B and K, and that those were also there. And the EQB did say, well, and did in that transmittal say, if you, please confirm that you have received these. I don't know if that was confirmed or not, but that was all in there, and it was up to the commission to confirm to the EQB that it had been received. So anyway, bringing this up in the briefing papers, I think needs to be corrected. And so I want to make sure that you do know that all the information was there, that the EQB did verify it, did provide it to the commission, and that, yes, this is a different procedure. This is under the jurisdiction of the Environmental Quality Board. And the Environmental Quality Board then gave the commission the things that it must deal with in that two-page transmittal letter, which I hope that you have in your record and have reviewed, because it is a different procedure.
Madam Chair,
Commissioner Tuma.
I got a decision option. Bob, could you put it up on the screen? Could Excel come up here just for a quick question? Make sure the parties get a copy of the.
Mr. Harris, could you state your name for the record, please?
Good morning, Madam Chair, Commissioners. Matt Harris on behalf of Excel Energy.
Commissioner Tuma.
Mr. I just want to make sure he gets a chance to read.
Oh, sorry.
Oh, this is different. Oh, you gave it to me. Oh, thank you.
Mr. Harris, I just want to make sure I get this right. I mean, you obviously heard and read through the record. It's your project. I don't think we need to do a discretionary EAW. I think we follow the rules, then we are exempt based the way I read it. So that's the language I put in there first. Deny because we're exempt. There's also language that says she didn't meet the standard with the filings for the petition. And then I also threw in a little thing on 5 just to make sure the technical things get done in the letter that needs to be sent from our executive secretary, or the findings that sent from executive secretary to the EQB. So just looking at you, do you need any more time? Do you need any more process? Do you need to review anything more to make sure you're okay? Because I want you to be able to work through this. Fine, I just want to make sure we're following the rules as you see we should be following them, and that this is sufficient to address what I think is unneeded, non-mandatory EAW.
Mr. Harris.
Madam Chair, Commissioner Tuma, thank you. And I also want to thank staff for the comprehensive briefing papers here. Quite frankly, as I see this, the environmental review that the commission needed to do is set out under Rule 78540500. That originally was an EQB rule that was passed consistent with MEPA, which allows the EQB to provide alternative review for projects, and also allows EQB to fully exempt projects of a specific type from EIS and EAW. And that's what they did when they passed the original version of 78540500. And I think that's frankly all the analysis that you need to do. You did the environmental review under Rule Chapter 7854. That's consistent with MEPA, and I think you end there. Frankly, as I look at the decision options, I think the addition that you put here makes a lot of sense, and I'm not sure you need to get to the merits at all.
That was my feeling, but I'm I just want to make sure you're tracking with it. I'm comfortable with where we're at, just to say we've done what we were required to under the MEPA law, but I just wanted to make sure you're tracking with it, because it's your project that you're trying to accomplish. It's your project you're trying to purchase and finish, so I just wanted to make sure you are fine with it. I think we're where we need to be, but that's my motion, Madam Chair, would be move my amended 4 and amended 5.
Commissioner Tuma, Commissioner Sugar and I did not see this motion before. It looks like it's consistent with the direction I was heading based on review of the record that's in front of us. But Ms. Overland, I wanted to give you a chance to respond to Commissioner Tuma's motion.
Thank you. Yes, it is our petition. It's important to note that 7854-0500 is application content rule. That is all it is. Application content for information to be provided by the applicant. That is not analysis. Number 2, saying that it complies with MEPA doesn't make it so. And application content requirement is not environmental review. And, as you know, I've been trying to get to environmental review for wind projects for 25 years now. There has not been environmental review of a wind project yet in Minnesota history. This is a problem. And we've had bent tree landowners bought out because of violations of noise standards. The commission has actual and constructive notice that there can be problems with wind projects. This project has had a stack of information provided by the applicants, which was needed, but that has not been reviewed. It's just been put into the file in both application for amendment, compliance filings in November, and more compliance filings in December. These have not been reviewed. There's not been any public process, no iterative process here. That's a problem, and this is not compliant with MEPA.
Thank you. Any additional comments or questions, Commissioner Sugar?
Madam Chair, I don't have questions. I'm assuming, are we in
We can move into deliberations.
I would just note that I appreciate Commissioner Tuma writing this up. The motion, Commissioner Tuma, that you've drafted and offered is exactly consistent with my read of the record and my discussions with legal counsel, and I support your motion.
On Commissioner Tuma's motion, all in favor, please say aye.
Aye.
Opposed? The motion prevails. Thank you, Ms. Overland and Mr. Harris.